So hello everyone, and welcome to our webinar on, we've called it Because Life and Death Happens, and Mary Hart, our guest presenter, will be teaching us the basics of protecting loved ones. I think this is an incredibly important webinar, workshop session for everyone on the call and for all of the clients we work with. And I want to wish all of you a happy day before Valentine's Day, and to point out to you that this is a particularly loving area to address and consider taking care of our loved ones. And I know that if I asked for a show of hands of how many people are excited to be thinking about and talking about and dealing with death today, we wouldn't get a large show of hands. But we're here, and certainly you show that you can appreciate that this is important. So let's go ahead and get started. So we will begin with a brief overview of financial social work, because we have new people with us today that don't know about our work. Then we'll learn important information about protecting ourselves and our loved ones. And later on, Mary Hart has just a wonderful, wonderful, very exciting resource. I'd never seen anything like it that she'll share with you, and it will be available to all of you. There will be audience participation. We'll have some polls, and we'll be asking you to raise your hands. You might want to take a look at your dashboard up in the right-hand corner and see how you can raise your hand, so that when the time comes, you can let us know if you belong in a specific area that we're asking about. Towards the end, you'll learn the topic of our March free webinar, how to access the post quiz if you've registered to take it for the 1CE, and when to expect the recording and handout that we've told you about. At the very end, I'll explain about financial social work certification, and we will have Q&A. Mary has a lot of material to cover today, and she has very generously agreed to stay with us to get through all of your questions. So at its core, financial social work is about personal, professional, financial, and social change. These are at the heart of true social work, and more than anything, at the heart of financial social work. And the work is about taking greater responsibility for your financial future, and requires more than just learning new financial skills, because change is a process, and financial stability is a very personal, individual, and emotional choice that we make daily, weekly, monthly, and perhaps at times minute to minute and hour to hour. So financial social work facilitates making the choice to do what you need to do to take greater responsibility for creating a better personal and financial future through ongoing education, motivation, and support. And certainly part of the education we provide is this free webinar every month. And then we're on Facebook and Twitter, and we are here to support our students, our graduates, and our community. And at its very heart, we know that your relationship with your money drives your financial behavior. And as you can see, it's your financial behavior which determines your financial circumstances. And certainly what we're going to be learning today is an important piece of that. So financial social work strives to change the conversation about money, to provide a different way of thinking about money, and to offer better ways of working with clients around money problems and issues. And all of you should have this little box up in the right-hand corner. It does change from time to time, but I did want to point out that you can enter a question And also, I sometimes call the question box and the answer box because sometimes you can answer our questions in that same box. You can click on the arrow. You may have a red arrow if you want to minimize that box to see the slides better. And then you've probably already made your decision whether to wear a headset or to just listen through your computer. So at this point, I will be going to Mary Hart's slides. And I will do that this way. Okay, so we're going to do this first little bit, about a dozen slides, with me moving the slides forward for Mary so that I can do the polls for her rather than handing off the slide presentation back and forth. So go ahead, Mary, your turn.
Hello, everyone. This is Mary Hart, and welcome to this webinar. And as Rita says, this is the very first webinar I've ever done. I'm used to reading the faces of the audience and telling whether you're bored or have questions or anything else, so I can't do that. So feel free to send some questions to Rita, and hopefully this will go well. But I'm very glad you've chosen to listen in because it is an extremely important topic and one I've been speaking on for about 22 years, and everyone is usually very thankful to have the information, so I definitely want to share it with you. There are a couple of things I want to point out before I begin. I am currently practicing in North Carolina, so the things I'm going to tell you are based on North Carolina law. In most other states, the laws will be similar, but you would need to check with an attorney in your own state for exactly what the law is in that state. If you're listening from another country, definitely consult someone in that country who'd be familiar with your laws, because I am not. In any event, let's definitely get started. What is estate planning? We actually called it life and death planning because it really is about planning during your life and for what happens at death. And the word estate planning sometimes throws people off because they think, well, I don't have an estate, I'm not rich, I don't need to do estate planning. But it's not really just for the wealthy. Estate planning is one of the most important steps that any person can take to make sure that your wishes about your assets, your property, your health care, all your wishes are honored and that loved ones are provided for in your absence. And even though it's very easy to overlook or put off your estate planning in favor of more immediate concerns, your estate plan can resolve a number of legal questions that arise during life and certainly at death, you know, about your financial affairs and what you own and who gets what, and do you need to appoint a guardian for your children, and will there be tax owed, and things like that. So I'm very glad you're here to listen in, and I really think that estate planning is taking control of what happens in the event that you become disabled or die, and it's really for everyone, not just for the wealthy. And I think Rita has an interactive poll. She wants to ask you a question at this point.
Thanks, Mary. I do. When Mary and I were discussing this webinar, she felt it would be helpful to her if she knew some things about our audience. So let me go ahead. We just have a few polls today, and as soon as I find them, here they are. We'll do the first one. No, that's not it. Okay, so going to launch the poll, and you will see we wanted to know who in our audience is single, married, is in a non-married couple relationship, and you can pick as many as are applicable. Okay, about 60% of you have voted. These are obviously anonymous questions, and just we love to have you participate. We think it makes for a more interesting session for you and for us. 83% of you have voted, and I'm going to go ahead and count off 5 seconds, so you have another 5 seconds to finish up, we're up to 87%. Sometimes I get 100%, and that's always fun. So 5, 4, 3, 2, 1, and I will go ahead with 88% of you who voted and close that poll, and I will share it with you. So even though I see a different screen than you see, Mary, you can see the results, right?
Yes, I can. Do you want me to read them off to you?
I can see it, but not in the format that you are. So,
okay.
So a significant part of our audience is married,
Okay.
and it's almost evenly split between over 50 and under 50. And I know that that's important to some of the things that you'll be covering. Right, Mary?
Well, it just helps me to know what stage people are in planning for their life and death, the age thing. I'm turning 50 in July, so I actually would come in right in between those two, I guess.
Okay, well, I'm on the over 50 for sure. I'm never going to see 50 again. So here we go. All right, so let's go ahead to our next slide. Here you go, Mary.
And essentially, I kind of jumped the gun
Okay.
on this one when we talked about basically taking control. And let me just make one other comment about that. You know, I've been doing this for about 22 years, and it is hard for people to take that leap and decide to do their estate plan because, frankly, who wants to talk about death and dying and disability and family dysfunction and all the things that come up when you're talking about an estate plan. But what I'd like to tell people is that really it's all about you taking control of what happens because things will be decided for you if you become disabled or you die. And if you have no plan in place, then some third party are making the decisions for you. That could be another family member. It could be your state legislators who've created certain default laws. It could be a judge. It could be a number of different things. And so really, to me, the important part of estate planning is that you get to take control and plan so that decisions are done the way you want them to be. And Rita, I would probably go ahead and do the next interactive poll before we get into the rest about estate planning.
Okay, let's do this one then. And I'm going to launch that one. And the question is, which of the following is or are reasons to have an estate plan? And again, you can pick and choose among them. There's not just one answer.
The slide says select one, but Rita, are you saying they can select more than one?
Okay. It does say select one? No, they should be able to select as many as they want.
Okay.
Okay. Thanks, Mary.
Mm-hmm.
I thought it was a good thing this was a good thing to think about before we actually get into the details of the work. We have one major winner here. 67% of you have voted. Okay, I'm going to go ahead and count it down. If you want to vote, go ahead now. 5, 4, 3, 2, 1. And I will close this poll and show you all the results. Okay. So everybody was listening to you, Mary. They know it's for taking care of yourself and the people you love. Should we tell them that they'll see on the next slide that all of those.
Pretty much it's all of
exactly.
the above.
Right.
All of the above. And every person really has different priorities and different reasons for why they choose to do their estate plan, but really all of those are reasons to do one. As you'll see from this slide, estate planning is a way to take care of yourself and the people you love. That got the most votes. Minimize the hardships of growing older. That's having people make decisions for you and you choosing who that person is. Ensure that less of what you've worked hard to accumulate goes to pay taxes. And you guys can read this. I don't want to just read the slides, but it is a way for you to take control of all of those things that are on the slide and even more. You can minimize or avoid costs associated with the probate process by using certain estate planning documents and devices. You can dictate the kinds of life-prolonging medical care you wish to receive should you be unable to make your own wishes known when the time comes. You can talk about the kind of funeral or cremation arrangements you would like. So this is just a short list of the many, many, many reasons why I think it's important to proactively plan your estate or do life and death planning. And basically, Rita, you can go to the next slide.
Mary, I don't want to throw you on this. I'm just curious as I listen, you know, when I knew this was important for everyone to know, and of course, I didn't call it an estate planning webinar because I was concerned that people wouldn't want to take an estate planning webinar.
Right.
So I'm curious, you probably don't know this. I should have looked it up, but I didn't think of it. Do you know where the term estate planning came from and how these came to be part of it?
I don't know specifically, but I can suspect it's a couple of things. One, I'm sure it was thought up by some lawyer, and you know we like lawyer job security, so we like to throw out words that nobody else knows what it means. But I also think, you know, an estate is the legal word for basically what one owns at the time of death. And so I'm assuming that estate planning came to be called that because you literally were planning for your estate, what would happen to it after you died. And it really is so much more comprehensive than that, but that language stuck in the legal world, and I'm assuming that's where it came from, but it's way bigger than that, and I think it's a misnomer, or certainly not as comprehensive a title as it should be. That's why we call it life and death planning.
Exactly.
Both. And I've done seminars where I've called it, you know, planning for death and disability, the good, the bad, and the ugly. I mean, it's death and disability, and just, yeah, not just an estate.
Thanks. So here's your next slide.
Right. So essentially, you guys can read this, but you can go about the business of living and just doing what you do day in and day out. If you go ahead and do your life and death plan, your estate plan, you can then put it aside and forget about it, probably forever, maybe at least for a long time, but probably forever, knowing that you've done, you know, everything you can do to protect yourself and the people and charities that you care about. And the bottom line is what I tell my clients. I really think it's one of the nicest gifts you can give to your loved ones is to be prepared. No matter what, the people that you love are going to be sad and grieving if you die or become disabled. And it just compounds their grief and makes it much worse if they have to figure out what they need to do after your disability or death. And the more things that you have in place to guide them, the biggest gift that is for them. So let's see. Yes, next slide. We're going to start with planning for disability. And you know, chances are that many or most of us will have some episode of disability, whether that's for a few days after surgery or whether it's for the rest of your lifetime because you've gotten Alzheimer's or you've become disabled in an accident. Most of us will face at least a day or more where we're unable to make our own decisions. And if you don't choose who makes those decisions for you and put that in proper documentation, then a court is going to decide. And sometimes that court decides based on who comes knocking at the courthouse door to ask for permission to make your decisions. That may or may not be the person that you would have chosen. You know, I'm one of 10 siblings when you count half siblings and step siblings and everything else. Most days there's not any one of them I would want making my decisions, although I love them all dearly. But I would want to choose who makes my decisions rather than wondering which sibling would go knocking on the courthouse door and asking the judge to take over all my stuff. So I think you should do these documents we're going to talk about in a minute so that you can take control over what happens if you are unable to make your own decisions. You can switch the slides, Rita.
Okay, so this is our last poll. So I hope we'll get a lot of participation. Let me get it up here. Okay. You should be able to pick more than one, but apparently you'll have to tell me if that works.
Slide says one, but you can choose more than
one.
one.
Oh, good. I think some of these things, the majority of us, excluding you, Mary, are familiar with, and some we aren't. And that's pretty clear from the results. Okay, about 60% of you have voted. This is the last one, folks. So, oh, we bounced right up there. Okay, so I'll count this down and I'll close the poll and show you the results and get ready to turn this all over to Mary. And 5, 4, 3, 2, 1, 78% of you voted. And this is what you said.
Okay. And the answer is actually all of the above on this slide as well.
And I didn't know those last two either, and I take it that most everyone, in the session weren't familiar with those either. So we have lots to learn so far. Okay, I guess I kept this up. I kept this one before.
Yep, we're going to go through all those documents. These 5 documents that you see on your slide now are the most common advance directives, and there are actually a couple of others that we see through this office sometimes. But let's talk about them, and I'm going to list them all. You can read them, and then we'll go through each one. So I guess Rita's got to raise your hand if you have any of the advance directives listed on the previous slide. We'll see how many people have done this.
Okay. So does everyone see that little hand that you can raise? Okay. We're getting a good turnout. I'm going to turn it over to you in a second, Mary. So right now, we have a pretty nice percentage. We have about 40% of our audience has at least one of those. We just asked how many of you have one. Mm-hmm. Okay.
Well, I think that's a great percentage. And
yes.
I have to say that you are all to be commended because that's pretty high probably compared to the population as a whole. So I'm proud of you guys who have done that. That's awesome. Are we ready to move on, Rita? Or are you still?
I'm turning it over to you, Mary. You have your slides up?
Okay. Yeah, let's see if I can make it move. Hold on. Oops. Hold on. Let me figure out how to do this. Okay. So I have to go to the slideshow. Sorry, guys. Please forgive me for my very first time here. Let me find the right one. Okay. Show my screen.
There you go.
Let's see. Do you see it? Right, from the current slide. Okay, that should work. Hopefully everybody will see it. If you don't see it, please let Rita know because I can't tell whether you see it or not.
Well, I can see it, so I'm going to assume everyone can.
Should be up. All right, so this first slide is the healthcare power of attorney. And that is the first document on the advance directives, and that is a document that you use to name the person who would make your health care decisions if you are unable to make your own decisions. And obviously that is very, very important because you may be in the hospital and unable to make your decisions, and someone needs to do that for you. If you do not sign one of these documents before it is needed, again, someone would have to apply to be appointed as your guardian. And what that would mean is they would literally have to file something with the court, ask to, one, have you found incompetent, and then once a determination of incompetency had been found by the judge, then they would ask that they be appointed as guardian. That process is quite time-consuming, often taking many months, and is quite expensive. I would say minimum $2,500. We've had guardianship cases that have been contested that have cost more than $20,000. And it's very, very expensive. So we want to have you avoid that by signing a healthcare power of attorney that allows you to appoint whomever you want as your agent. And I usually encourage people to name at least 3 layers if they can. Who would do it first, and then if that person is unable, who would do it second, and then who would do it third. I think it is most important to choose the person that would make the decisions you think would be good decisions rather than worrying about geographic location. Although all things being equal, if you've got people who would all be great choices, then it's probably helpful to have someone that's in the area where you are locally, but that's not 100% required. So that's a healthcare power of attorney, very, very important. The next document is a durable power of attorney, and that is essentially a power of attorney for everything but healthcare. And that is, who would make your decisions about paying your bills, hiring your housekeeper, signing you up for insurance, all those things. If you think about every decision you make from the time you put your feet on the floor in the morning to the time you go to bed, all documents you sign, checks you sign, everything else, if you're unable to do that, the person you name in your durable power of attorney would be the person to take that on. There is one aspect of this document that is critically important that some people miss if they're just picking up a document from a stationery store or LegalZoom or something like that. So I want to point it out. That word durable in the durable power of attorney is what it means, that that power of attorney will endure a subsequent disability. So if you sign a durable power of attorney and you want it to remain in effect, if you subsequently become disabled, it needs to be a durable power of attorney. And all that means is that it's got a sentence somewhere in that document that reads something like, this power of attorney shall remain effective in the event of my subsequent disability. If you don't have that language in your power of attorney, it is not durable, and the moment you become incapacitated, it is revoked by operation of law. And I want to give you a little war story about this to bring this home. When I was a baby attorney, I was practicing law in Alaska and in Juneau, and I had a client who came to me from Ketchikan, Alaska, and that was a ferry ride away, so she'd taken a whole day to come into Juneau to meet with me, and said that she needed for me to draft a deed to sell an apartment building that was owned by her husband because her husband was in a long-term care facility for Alzheimer's. And she handed me the power of attorney that her husband had given her many years ago. And I looked at it, and it did not have that sentence. It said it remained effective in the event of his subsequent disability. So I asked her a few questions and determined that this man was completely incompetent. He didn't even know who he was, much less who she was. And I had to tell her that that power of attorney was revoked by operation of law the moment he became incapacitated. So I was not able to draft a deed for her because she had no authority to act for him. So what we had to do was go to court and ask to have her appointed as her husband's guardian. We had to give notice to all of his children, which included an adult child that was not her child, and they had not been in touch with that woman for over 40 years. And my client was petrified that this woman was going to cause problems. Anyway, the short story is that this took probably 6 months and many thousands of dollars to get her qualified, and all because that power of attorney was missing one sentence. They had bought it at a stationery store and had picked up a general form power of attorney and did not realize it was missing that language. So if you do your own power of attorney, or if you're talking to someone about doing one for you, just make sure that it is a durable power of attorney and has that language in it. Extremely important. All right, let's move to the next one. The living will. This is what we very crudely call the pull the plug document. And as you can see in the parentheses, it's declaration of a desire for a natural death. This basically is a document that you fill out that allows your loved ones to ask the hospital or medical facility to terminate life support in certain situations. And you get to choose basically what those situations are. They're the trigger events. And if you are in one of those conditions, to a high degree of medical certainty will not come out of that condition, then you have indicated that you not be kept alive on artificial life support. And without that document, in most states that I'm aware of, your loved ones cannot force the hospital or doctor to terminate your life support unless you have signed that document previously. And there have been a number of cases in the past. Karen Ann Quinlan, I think, was the first, and then Nancy Cruzan and Terry Schiavo, and you may have heard of some of these cases where people were basically in a persistent vegetative state and left in that condition for many, 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 many years because they had not signed a living will before their accident or whatever put them in that condition, and so there was no authority to terminate life support. It's a very, very personal decision whether or not you sign one of these documents. I would say probably 99% of my clients do sign them. If you do not want to be kept alive on artificial life support, it is critically important that you have a document like this. One of the questions that I've heard over the years is people are afraid if they sign one of these documents that the hospital is going to be too quick to terminate life support. And I usually say, in my experience, it has been the opposite of that. This is the sword that your loved ones use to ask for life support to be terminated when a medical facility will not terminate life support. And frankly, why would they be motivated to terminate your life support? You know, they're making thousands of dollars a day off your medical care, and if they terminate it and some family member starts screaming, they're afraid they're going to get sued. So in many cases, I could see where if you don't have a living, or if you have a living will, that's the only protection that you have to allow your family members to force the termination of life support. So I think it's a very critical document, and if you feel that you would not want to be kept alive artificially, you should definitely sign one of these documents. And let's see, moving on. Authorization for the release of protected health information. I see I have a little typo in authorization. I apologize for that. We call this the HIPAA waiver, and you guys might have heard of HIPAA when you go to the doctor's office and you have to sign that you're aware of the privacy laws for your medical information. We worry that your healthcare agent, the person you have named to make your healthcare decisions, won't be able to get your medical information because of the HIPAA privacy laws and won't be able to make an informed decision. So we actually have you sign a waiver of that HIPAA privacy law for your healthcare agents, basically allowing them to get your medical information so they can make an informed decision. And you'll notice on the right-hand side, I'm showing you North Carolina documents, of course, and where we have Social Security number, we do not recommend that people put their full Social Security number in there because of identity theft. We just have you put your last 4 digits of your Social Security number. So if you're doing this yourself, I would encourage you not to put your full number there. Okay, let's see. This last one and the one I'm getting ready to say are the ones that most people don't realize are advance directives. And I should go back and say an advance directive just means you're saying something in advance of a disability. That's all it is, a directive of what happens, and you're writing that in advance. That's where we get the term advance directive. Anyway, hospital visit authorization form. In some cases, if you are in a restricted medical facility, say like intensive care, there are sometimes rules that say only immediate family members can get in to see you in those restricted medical facilities. And in some cases, that is a problem. For those of you who are in non-married couples, or those of you who are single and maybe have a best friend you would want to come visit you, they're not considered immediate family members. Your non-married partner is not considered an immediate family member, even if you've been dating for 40 years. And so we use this document to basically designate non-family members that you would want to go to see you in a medical facility. And in North Carolina, and probably in most states, but in North Carolina there is a patient bill of rights that specifically says you can choose who gets to see you in those situations. So that's what this document does, and we use it a lot for non-married couples. Like, I'm in a relationship, my boyfriend, I'm not married to him, but I would want him to be able to get in to see me. So I have given him a hospital visit authorization to get in to see me. All right, moving on.
I just want to say that we're getting a lot of questions, and I want everyone to know that we're going to answer those at the end of the session. Mary just has so much to get through, so I don't want to stop her. Thanks, Mary. Go ahead.
Sure, and I think we'll have plenty of time for questions, and I'm happy to hang on the line as long as we need to answer questions. So just hang in there. Okay, who gets copies of your advance directives? This to me is a very personal choice. I think your medical advance directives, you should put a copy in your doctor's file if you have a personal physician. Your agents, those are the people you've named in your documents, whether or not you give them copies is sort of dependent on whether you want them to have copies and whether you think you might ever revoke those. I usually prefer to tell people where they are, because if you're populating the world with copies to all your agents and then you change your mind on who you want to be the agent, you now have to go back to that person and say, guess what, I named you on day 1, but now I've changed my mind, please give me back that document. And that makes me uncomfortable. So I usually just let people know where the copies of my advance directives are, let them know if they've been appointed, and then, if I've changed my advance directive, then I'll let the other person know, and that should be fine. Where should you store them? This is always a big question. I've had firefighter clients tell me to put them in a fireproof box in the freezer because the freezer is the last place to burn in your home, and so if you die in a fire and your documents die with you, that's kind of a problem. There are online registries. The state of North Carolina has one. There's one that's all over the world called docubank.com, DOCUBANK.com, and for a relatively nominal fee, you can submit your advance directives to this repository. They issue you a card. It looks like a driver's license, but it has an account number and how people can get in touch with DocuBank 7 days a week, 24 hours a day, by phone, fax, or internet. I think that's a good way to do it. There are dangers with safe deposit boxes. It's sort of a catch-22 situation. For instance, let's say you've named someone as the agent under your durable power of attorney. If they are not listed as a signer on your safety deposit box, they can't get into the box to get your power of attorney unless they've been appointed as the power of attorney, and they can't prove to anyone they're the power of attorney until they get in to get the document. So it's this catch-22 situation. The same thing with your will. Nobody can get into the box unless they're your executor, your personal representative, but they can't get appointed as your executor until they can get into the box and get the will. So it's a catch-22. I usually tell people if you're going to use the safe deposit box, then you need to have anyone you've named as your agent, your executor, whatever it is, as a signer on the box. And that's not always a real smart thing to do either, depending on who you've named. So it's a little bit tricky question. Some states will have a depository system at the courthouse, so they'll keep at least your will, if not your advance directives. But in any event, the online registries, either with your state, Secretary of State's office usually, or with docubank.com, I think is a good way to go. Okay. I'm sure we have lots of questions about the disability section, and Rita, I'm happy if you want to stop and take questions on that piece, or if you want to go on, it's up to you. However you think we're doing on our time.
I think you still have a lot to cover, so I think
Okay.
we need to go on. But we do have plenty of questions.
Okay, and we'll have plenty of time for answers. So let's move on. Planning for death, it is inevitable. So far, they haven't figured out how to keep it from being inevitable. And again, planning for death is, in my opinion, maintaining control. And there are a number of concerns. You know, people want to die with dignity. That's what the living will that we talked about, not being, you know, left on a artificial life support when you don't even know who you are. Who inherits your stuff? Do those people inherit it outright or in a trust? Are you going to pay taxes or probate fees? How do you minimize or avoid all that stuff? Those are some of the concerns that we have when we're planning for death. And I see we have a raise your hand question, so please raise your hand if you have a will. Virtual raise your hand. I can't see the hands, Rita, so I guess
Okay.
let us know.
Dashboard. Let's see. So far we have 19% of our audience has a will, and it's slowed down an awful lot. That's it? Anybody else want to raise your hand? Okay, we're up to 20%. Well,
that sounds like a more likely percentage based on what I hear out in the world and at large. Is very few people have done a will, and it's who wants to think about it? I mean, nobody wants to think about it, and there are always more pressing things to do. You've got to get your bills paid, you've got to pick up the kids at school, you've got to work, whatever it is. So that does not surprise me at all. And a will, we'll see in a minute, you know, what a will does for you and what it does not do for you, and that can help you decide whether or not you want to sign a will yourself. The first thing when we're doing an estate plan or a death plan is to determine what is in your estate, and we determine that by figuring out what it is that you own and how it is owned. And when I say something you own, that could be real property like a house or land. That could be intangible personal property like stocks, bonds, bank accounts, IRAs, that sort of thing. It could be tangible personal property, which is the stuff, your artwork, furniture, jewelry, collectibles, things like that. Your estate consists of all of that, anything you have an ownership interest in. Next, we're going to look at how it is owned, and you'll see why this becomes important in a moment. Is it something you own in your individual name? Is it something you own with a joint owner? And if so, does that have a right of survivorship or not? Is it something you own as a beneficiary of a trust, or is it something you're entitled to as a beneficiary of, say, a life insurance policy or a retirement plan or something like that? So you want to make sure that you're using the right documents to get the assets to the right people when you die, because how those assets are titled dictates how they pass at death. And the document you use will depend on how that property is owned at the time of your death. And we hear people use the word estate in different ways. When I say everything you have an ownership interest in, that is technically your gross estate, and that's a term for what we use for federal estate tax purposes, or just making sure we know how everything is going to pass at death. We're looking at your gross estate, which is everything you have an ownership interest in. If you hear the word probate estate, that is assets that you own in your individual name, meaning there's no joint owner, there's no trust, there's no pay on death beneficiary, it's just you and your individual name. For instance, my house is just owned in the name of Mary Hart. That is a probate asset. If I owned it with my mother, it would no longer be a probate asset. If I owned it with a right of survivorship, if I died, it would pass automatically to her. So then it's no longer in my individual name. The only things that go through your will are your probate assets. And this has become a problem in many cases where people think they can draft a will that covers everything they have an ownership interest in, and they don't realize that some of those items will not pass through their will. And to give you a quick example of that, I represented two sons of a woman who died in her late 40s or early 50s in a scuba diving accident. And many years before she died, she had done a will that left everything in equal shares to her two sons. And then years later, she changed her retirement benefit beneficiary designation. Let me see if I've got this right. No, I have it backwards. She had a will that left everything to her two sons and her partner. That's what it was. The will left a third, a third, a third. But on her retirement plan beneficiary designation, which she had done before her will, she had left it just to her two sons. Then later when she changed her will, or she did a will that said to her two sons and her partner, she assumed that would cover every single asset that she had. But she didn't realize that it would not cover the retirement benefits because they were governed by a beneficiary designation form. They were not in her, it was in her individual name, but because it had a beneficiary designation, it did not pass through her will. So when she died, I'm sure she assumed that her partner would get a third of her very substantial retirement benefit assets, and it didn't happen that way. It just went to her two sons. And I ended up representing the sons because the partner was threatening to sue to get a third of those retirement benefits, and we ended up settling it, but really the partner was not legally entitled to anything from that retirement benefit, and I'm sure the deceased woman had no idea that would happen. But it's a very common thing for people not to understand the concept that the only items that pass through your will are things that are in your individual name at the time of death. And whether that's real estate or bank accounts or stocks, you know, if it's in your individual name, it will go through a will. If it's not in your individual name, if it has a joint owner, or it's through a trust, or it has a pay-on-death beneficiary, it's not going to go through your will. Very, very important. And I always get lots of questions on that, so I'm sure we'll get some and we'll answer them. So let's assume we're now talking about the probate assets, the things that go through your will. What does a will do for you? Well, it provides for the distribution of your probate assets, those things owned in your individual name at the time of your death, in any manner you choose. The only people that you have to leave assets to are a spouse, in most states, a spouse or children born after the date of your will. Otherwise, you can disinherit anybody you want to. If you want to disinherit a spouse, in most states they're going to have to sign a waiver that gives up their right to a share of your estate. Otherwise, generally speaking, a spouse is entitled to 1/3 of anything you die with, and that's called an elective share. They don't get it automatically. They have to make an election with the probate court to take 1/3 of your estate, but they do have that right in most, if not all, states. So if you want to disinherit your spouse is going to have to consent to that. And again, you see my warning on the bottom of this slide that a will only covers those assets held in your individual name at death, and that is critically important when you're deciding how you want to leave your assets. All right, so we have another raise your hand. Raise your hand if you have a family member that you would not want to inherit any of your assets if you die. So family member that are, parents, children, grandchildren, siblings, aunts, uncles, nieces, nephews, all of that. So raise your hand if you would not want a particular family member to inherit.
Okay, we're up to 22%, 23, 4. Well, at least a quarter of our audience has people, family members, they do not want to inherit.
Okay. Well, then don't cut off on this seminar because you're going to hear how we make that happen. All right, let's move to the next one. We have another raise your hand.
Okay,
raise
wait, let me lower the hands. Okay. Okay, go ahead.
So now raise your hand if you have a non-family member you would want to inherit your assets if you die. So if you have a partner, a friend, a charity, your dog, anything like that that is not a family member. And I know a dog is most people's family member, but not in the law, sadly.
Okay, we're at 22%.
Okay, so that's also very important for the next section that we're going to talk about. Basically, if you have family members you want to disinherit or non-family members that you would want to inherit, you must do something, probably with a will or a trust, because in most states, and certainly in North Carolina and in Alaska where I practiced before, if you do not have a will, the legislature creates a will for you. That legislative will dictate who gets any assets that you held in your individual name at death. So if you have any of those assets in your individual name, you can use a will to change what the legislature has said for you. We'll go through that a little bit more in a few minutes. You can also make sure that people receive what you want them to inherit by naming them as joint owners or beneficiaries or trust beneficiaries. But whether or not you do any of those things really depends on your goals and your circumstances. So don't rush off and make people joint owners of your accounts without consulting with someone or thinking about it, and I'll tell you why. I've had a lot of clients over the years. Let's say they've had 3 children, and they have a will that leaves everything in equal shares to their 3 children, and that's what they want. They want to benefit them all equally. But for convenience purposes, maybe they've made their eldest daughter a joint owner on their bank account because they don't want to pay their bills anymore. They want their daughter to be able to do it. And but they want that account, what's left in it, to go to all 3 children when they die. Well, because they've just made their daughter a joint owner, they've now made that a type of account that will not go through the will. So even though the will says I leave, all my assets in equal shares to all 3 children, that bank account will pass only to the daughter who is a joint owner and will not go to all 3 children. And I've had some clients who say, well, that's okay. I know my daughter will share it. She knows what my intention is. And that's fine. And that does happen sometimes, but it certainly does not happen all the time. When money is involved and grieving is involved, things happen that parents don't want to think about, number one. But even if we do have a daughter that wants to do the right thing, depending on the amount of money in that account and what she's got to share with her siblings, she may be making a taxable gift to them when she gives them a third of that account, each of them a third of that account. Under the current law, she can only give them each $14,000 a year without having to file a gift tax return. So if that account was $100,000 and she's giving each sibling $33,300, she's now got to go file a gift tax return and use up part of what she'd be able to leave tax-free at death. So that is not at all what the mother would have intended. And so instead, I would have told that mother, leave the account in your separate name, give your daughter the power of attorney and allow her to pay your bills as a power of attorney but not as a joint owner. So that's just one way that you really have to pay attention to how things are titled. So the will distribute the assets that you hold in your individual name, and you can do these other things as well. Designate guardians for your minor children, designate the executor, which we call a personal representative in North Carolina, and eliminating the need for a bond. In most states, if you do not have a will that waives the bond requirement, then whoever goes to administer your estate is going to have to post a bond out of their own funds. And they do that basically by going to an insurance company and paying for a bond that guarantees the performance of their job. So if they rush off and abscond with all the money in the estate, the bond would pay off, just like a bail bondsman kind of thing. But that executor's got to pay for that bond out of their own pocket. So when you do a will, you can put in language that waives the requirement for a bond so that your executor doesn't have to post a bond. We can create trusts for minor children or special needs beneficiaries, people who are qualifying for Medicaid or other government benefits or who are unable to manage money themselves. If we don't have a will and things pass to children, then they inherit it at the age of majority in whatever state that is. In North Carolina, it's age 18. I have 3 sons. My oldest is almost 21, and I guarantee I know what he would do with money if he inherited it now, and it would not be responsible. So I could, in my will, which I have done, is create trusts for those children that say the trustee can pay expenses for them, for their health, education, things like that, but they don't get the money outright until they reach certain ages. The will can also provide for charities of your choice. We can use it to accomplish estate tax savings, in some cases income tax savings. We can provide for pet guardians. We can provide money to the people who are taking care of your pets. In some cases, people set up trusts for their pets even. So there are many, many things that a will can do that your legislative will does not do for you.
Mary,
Yes.
Mary, I need you to keep moving along because
Okay.
we're way over time.
We're running out of time.
Yeah,
Okay.
yeah.
So you'll see what a will does not do for you. It's not going to govern any of those other forms of ownership that I've talked about, things that are not in your separate name. If you die without a will, the legislature says who gets it, and it's not always who you think it is. In North Carolina, if you're married, part of it goes to your spouse. The rest will go to either your children if you have them, and if you don't have children, to your parents if they're alive, or other family members. So most people think spouse gets it all, but they don't necessarily. So it's important to know who would get it if you die without a will. Again, this is just reiterating what I said before. You must know how your asset is owned, how it's titled, so you know how it will pass at death, and that will govern what you need to do to make sure the right people get the right things. Here, just the way assets pass at death. We've talked about all this, so I'm going to move on. You can leave assets to beneficiaries outright, meaning they get it right away. You can leave it to them in a trust where it's deferred, that they get it sometime in the future. You can leave them the income only from an asset, or you can give someone else the income, and then when they die, somebody else gets what we call the remainder interest, what's left. Special considerations, I'm not going to go through all these, but there are a number of things that should be thought about when you're doing your estate plan or your will. Planning for non-married couples is very important, and I think we have one more raise your hand. Do we have time for that?
No,
Rita?
let's go ahead without that.
We know that we've got, yeah, we already have that too, how many people are non-married couples. The only thing I would say about that is, as a non-married couple, at least in most states, certainly in North Carolina, you are legal strangers to each other. It is as if, you and I were trying to do something for each other. You don't know me, I don't know you. The law does not protect you. So couples who are not married, whether you're the same gender or different gender, face some hurdles that married couples may not face. So you just need to make sure you use the documents such as those advanced directives, living wills, healthcare power of attorney, all that, and a will to make sure that your partner is taken care of. And this is just a list of documents that non-married couples should consider. We've gone through almost all of them. The last 3 are ones we have not talked about. Domestic partnership agreement can govern a lot of things. It's similar to a prenup, prenuptial agreement, making sure the deed to your real property is worded the way you want it to be worded. And if one parent has a minor child and wants the other partner to be able to make decisions for that child, then we need some sort of authorization. This is just suggestions concerning contents of a will. I don't think we need to go through that. If you are going to draft your own will, you can call me, and I'll show you my number later. You can call me if you need to, and I'll tell you what these suggestions are.
And also, everyone will get a link to the recording, so you can always go ahead and watch it on the recording. Mary, go ahead.
Yeah, glossary, we'll go through all that, and
Well,
one other
Mary
thing
put
just
together all of those terms, and I went ahead and put them into your handout. So you will receive all of those terms in a handout.
So basically, just to summarize, there's a lot of information. It's overwhelming. Just remember that this is the way you retain control over what happens if you become disabled or die. It's one of the best gifts you can give your loved ones, and it's not as difficult as you think it might be when you sit down and talk to someone about it. The bonus resource, if I can get to it somewhere on my screen, whoops, is my website, and I don't know how to get it up. I had it up, but it disappeared. Let me tell you how to go to it and what it is.
I do have the link on the handout because it is so fabulous. See if you can find it, Mary.
Let's see. Okay, here we go. I think, hopefully, Rita, can you see that? The website? I just pulled it over?
I can.
Okay, so that's the website, the Hart Law Group, and it's just www.thehartlawgroup.com. What I want you to see, I'm going to scroll down at the bottom, there's something called Estate Manager Web. And what this is, it's a free resource that anybody can access by going to our website, and it has step-by-step guide of what to do when you're planning your own legacy, your life planning, medical directives, if you're preparing for your end of life, and then also what you do if a loved one has died. And it has a whole list of steps in week 1, month 1, all these different things that you would need to do. So you can all access that for free on my website, and it's got lots of great tools. There you can order books and things. They're not coming from me. I have nothing to do with that. I'm not selling anything. It's just a free resource. So I just leave that there for you if you want it. And Rita, I'll let you take over now.
Go ahead and pass it back to me, Mary.
Okay.
Go up to Change Presenter.
Change Presenter. Yep, and I'm clicking on you. All right. You should get it.
Okay, show my screen. Mary, thank you so much. That piece on Mary's website is just, when she walked me through that, I was amazed, and I was so excited that everyone who attended would have that terrific resource. So I'm just going to finish up now with a couple of things. Those of you who requested to take the 10-question quiz for the 1CE offered by NASW North Carolina, I want to make sure that all of you know that in 1 hour you should receive a follow-up email from GoToWebinar. That's the platform we use to do this webinar. And in it is the link to that quiz, and many of you have requested it, and if you didn't request it, you will have that link if you've changed your mind and want to go ahead and take the quiz. And I believe you're only charged the $10 that they charge if you pass, if you get 8 out of the 10 quiz questions correct. Everyone who registered for the webinar will receive a link to the recording, including it also includes the handout. You'll have that by the end of the week. I wanted to remind you that on Wednesdays on our blog, it's always about, we call them Goal Wednesdays, because last month's webinar was on helping clients set and achieve financial goals, and we said we would support you all year with goal posts, Goal Wednesday posts in our Learning Center. So in that follow-up email that you'll get in an hour, there's a link, and it will take you to NASW North Carolina and right to this page, and you will be able to click on the link and go ahead and take that quiz. This is the handout, and you can see that I highlighted Mary's website because it's just some really, really great information, and there's the estate planning glossary. I wanted to tell everyone that our free webinar next month the topic is Who is Poor in This Country and Why? And it will be on the feminization of poverty and how feminomics and financial social work provide important skills and tools to address this serious problem. It is not for women only, it's for anyone who cares about why there is more equality in this country. So The invitation will go out, but if you would like to register right now, you can at financialsocialwork.com/webinar. And just to finish up before we do the questions and answers, Financial Social Work Certification incorporates 5 workbooks. It's done independently. It's all downloaded from the internet. Our students have 6 months to complete the certification, and there's an online exam that students have 2 weeks to complete. And most of all, I would like to share with you, why financial social work? Why have we certified people across the country and around the world? Well, I think it's because of these reasons. Because it's about financial behavioral change. We bring hope as a foundation to change because hopelessness closes the door to change. Through the certification, our graduates help all client populations to feel better about themselves, to be more success-oriented. It increases personal awareness. It helps set personal and financial boundaries, help people to identify where they're going, and to create a better, more emotionally and financially stable future for themselves and for their clients. And so, we now have many questions to go through for Mary to answer. I thank all of you who stayed with us and those of you who joined us, and I'm sorry if some of you couldn't stay with us. So let me get this set up so I can get these questions answered. It is bouncing around on me. Okay, let me see if I can do it this way. Okay, so we had a question very early on, Mary. I'm going to start with the first questions.
Okay.
Aren't the laws that indicate who can make decisions on your behalf even without going through the courts? Are there laws that indicate who can make decisions on your behalf even without going through the court?
Well, I'm going to speak for North Carolina and for Alaska, which is, generally speaking, no, because you don't have an automatic right to decide, say, for your spouse. You probably do for your minor child in most instances. Some hospitals, nursing homes, things like that, will listen to a spouse before it gets as serious as, say, surgery or something like that. But generally speaking, you need to be appointed as someone's power of attorney to make their decisions, or you have to go to court and get appointed as their guardian. We see it all the time where we can't make decisions just because of a relationship.
Okay. Could you repeat the sentence needed for a durable power of attorney?
Certainly. Something along the lines of, this power of attorney shall remain effective in the event of a subsequent disability. This power of attorney shall remain effective in the event of a subsequent disability or my subsequent disability, either one. You're essentially, the idea is you're just saying affirmatively that you intend for this power of attorney to remain effective even if you become disabled or incapacitated.
Okay, do you need a health care power of attorney if you are married, or is your spouse automatically appointed the health care POA?
The spouse is not automatically appointed the health care power of attorney in most states. And I don't know of any state that the spouse is automatically appointed, but I'm not licensed in all states, so. But
okay.
Usually you need to have that power of attorney.
Someone asked, are you going to review if any or all of these documents need to be notarized or filed with an attorney?
Every state has different laws as to the formalities of what is required to make the document effective. I can give you a brief rundown. In North Carolina, we need 2 witnesses to make a will valid. We need 2 witnesses and a notary to make it what we call self-proving, where we don't have to pull the witnesses up on the stand to say they witnessed the will. Powers of attorney have to have 2 witnesses. Health care directives have to have 2 witnesses and a notary. So it depends on the state you're in. None of them ever have to be filed with an attorney's office, and whether or not they have to be filed with the state or in the registry of deeds, for instance, will depend on the law in that state. In North Carolina, a power of attorney must be recorded in the Register of Deeds once the person becomes incapacitated. So if I give someone my power of attorney, I do not have to record it, but if I become incapacitated, it needs to be recorded before it can be used. So you're going to have to look at your state's laws to determine what the formalities are in terms of witnesses and notaries and whether or not it needs to be recorded in the state.
Thank you. I live in North Carolina. Where can I get a copy of the HIPAA waiver and the hospital visit authorization form to complete? Do they have to be completed at an attorney's office?
They don't have to be completed at an attorney's office, and I'm happy to give you copies of those. You can go to my website and get my phone number, or if you're writing this down, you can call me at 828-271-4278. That's Hart Law Group, and I am Mary Hart, and I'll be happy to email you blank copies of those documents.
You are too kind, lady. Some states allow for a will search of a safe deposit box with only proof of death. Minnesota is one. Someone shared that with us. Thank you. Okay, while filling out these advance directives, who should fill them out? Do you do this in front of a notary or attorney? So you've kind of covered that already.
Yeah, I would just add one thing. At least in North Carolina, the forms that the legislature has created are somewhat counterintuitive. So we really encourage our clients to, give us the information. We draft most of it, and then there's certain parts they fill out, but we like to be with them to go over the document to make sure that they're signing it the right way, because it's a little confusing.
Well, there's a couple questions on the PowerPoint being available and emailing the presentation. One more time, I'll explain to everybody that you will get a link to this recording by the end of the week. We don't send the whole slide presentation. So someone asked, does this include legal spouses who are legally separated at time of death?
The answer to that is yes. If you are married, even if you are legally separated, at least in the states in which I have practiced, that person is still considered your spouse. And I have been involved in a case where someone was legally separated for like 30 years, but they just decided never to get divorced because neither one of them wanted to be remarried. They were amicable. They didn't care. One person died, and we had to basically give everything to that estranged spouse of 30 years because that was who was entitled to it under the law. Because the deceased person had not done a will stating otherwise.
I don't see a question. I have a child with special needs who cannot directly inherit anything from my estate.
Yes, we often set up what we call special needs trusts, and those we do that through a will or as a standalone document, and that allows you to leave money for the benefit of a disabled child in a way that does not disqualify them for Medicaid or Social Security disability or whatever they are receiving, but does provide a pot of money to pay for things that the government benefits do not pay for.
Thanks. What is self-proving?
Self-proving is language that we add at the end of a will with a notary. So if we have a notary who notarizes the testator's signature, that's the person who does the will, and the witness's signatures, then that will is self-proving. I mean, when somebody dies, we turn that into the court and it is proven as a valid will. We don't have to go find the witnesses and put them on the stand in the court and have them swear that they were the witnesses. When their signatures were notarized, that's what did it.
What if you have children who are not getting along? Can you designate another family member that's not your child to handle your affairs? Absolutely.
You can choose anybody you want to serve as your executor. It does not have to be a child. In fact, in many cases it probably shouldn't be a child, particularly if they're not getting along.
I'd like you to know, Mary, there are a number of thank yous here for the great presentation.
Well, you're quite welcome. Quite welcome.
What type of trust should a person set up if they want to provide for a minor child?
Well, that's a big, broad question, and there are many, many trusts for many purposes, but a standard type of trust that we do here that either you leave as part of your will or as a standalone document leaves it in trust. We name a third party to manage that money. We usually say that until the child reaches a certain age or ages, the trustee can use that money for that child's health, support, education, or maintenance, and when the child reaches certain ages, they get it outright. Like for my children, I have my children getting a third at 25, half at 30, and the rest of their trust at 35. However, now that my oldest son is almost 21, I'm thinking of revising those ages. They don't get it till 30. But in any event, so that's just one example. That's really something you should talk to your own advisor about because there's so many factors that go into making that decision.
What type of lawyer should I search for to get this kind of help where I live?
A darn good one. No, just easy. You'd really look under lawyers that advertise either for estate planning or wills and trusts. It's usually, if you're looking in the yellow pages or on Google, put in, estate planning, trusts, things like that, and you'll find the right type of lawyer.
Okay, it looks like our last question. If not a North Carolina resident, other than a stationery store, do you have a recommendation of where to get these documents other than an attorney?
Not really. I have had clients who have brought me documents from LegalZoom or things like that and asked me to review them. And in some cases, the documents are fine for what they purport to do. The biggest problem I see with stationery store documents and LegalZoom is that you don't know what you don't know. And so those documents can't ask you questions and help ferret out what your goals are and what your circumstances are. And so the documents are often incomplete in the sense that they don't really cover your situation, or they're wrong because they didn't know, for instance, that you had a disabled child. And so they're leaving things in a type of trust that will disqualify the child from receiving Medicaid. So really, I think the safest place to do it is through a lawyer. If you're not going to do that, then go educate yourself as much as possible with online resources, and then use, say, a LegalZoom or something that is updated for the law. I wouldn't just pick up forms at a stationery store. I'd rather see you do something online if you don't want to use a lawyer.
Okay, one last one. How long after a loved one dies should an executor obtain the will and begin the probate process?
Well, you can do it, of course, as quickly as you want to. Some people need to get money distributed and want to do it relatively quickly. Most states, you have at least a year before you have to file it to get the probate started. So it really depends on the law in the state where you're located or where the person died, which is really what the rule is where the person was living at the time of death. So it just depends. But you usually have either from right away to at least a year to get it filed.
Someone shared with us that many hospice organizations provide health care POAs to the public and to their patients. Thanks for sharing that.
Yeah, that's great. There are also some other types of documents. 5 wishes you might have heard of. In North Carolina, we have a most form medical order scope of treatment that a doctor can do with you to really delineate some of your medical decisions. So there are ways you can get them.
It looks like that's it, Mary. I just can't thank you enough for sharing this with our community and for taking the time and spending the time.
My pleasure. Thanks to everybody who participated, and thanks especially to those who hung out after the allotted time. I appreciate it and hope you got some useful information out of it.
All right. Thanks, Mary. Bye, everyone. I hope to see you back here a month from today. Oh, someone just said this was awesome. Thank you.
Oh, great.
Lots of thank yous. Thanks, everybody.
Right.
Bye now.
Bye-bye.